everyone. Welcome to IPWatchdog Unleashed, where each week we journey into the world of intellectual property to discuss the laws, news, policy, and politics of innovation, technology, and creativity. With analysis and commentary from industry thought leaders and newsmakers from around the world, IPWatchdog Unleashed is hosted by world-renowned patent attorney and the founder of IPWatchdog.com, Quinn, who has twice been named one of the most influential people in the intellectual property community and recognized numerous times as one of the top IP strategists in the world. Take it away, Gene.
Thanks, Renee, and welcome everybody. Thanks for joining us this week on this edition of IPWatchdog Unleashed. This week I have a conversation with two very good friends of mine who you've probably seen on panels at IPWatchdog events and who have also both been on this podcast before. And along with myself, they're also co-founding members of what we all refer to as the Leesburg Patent Bar Association. So we're not just friends, but we're really neighbors as well. First is Brad Close, who has known me as long as anyone else in the industry because we went to law school together at what was then Franklin Pierce Law Center, and today is Franklin Pierce School of Law at the University of New Hampshire. Brad is Executive Vice President of Transpacific IP. And I'm also joined by Jim Carmichael, a former judge on the Board of Patent Appeals and Interferences, which is what the board used to be called before it became known as the PTAB. And now Jim is founder of Carmichael IP, which has one of the highest success rates of any firms at the PTAB for patent owner side representation. Thank you both for being here. I really appreciate it. Now, as we get going, we're going to talk about the PTAB, which I have on the brain. We have our PTAB program coming up at the end of January. It'll be on January 29 and 30 at IPWatchdog. So everything right now as I prepare for that event is PTAB related in one way or another, at least with respect to what I'm thinking about. So today, here with you two PTAB experts, Jim on the attorney side and Brad on the patent owner side, I thought we would just start with a very open-ended question. Brad, I'll go to you first. What's your take, generally speaking, on what's going on at the PTAB these days?
Well, I think the quick summary is I'm extremely happy. There was no question that there's a lot of bias, I believe, in the original framing of the PTAB, where the people who are being employed there decide if the patents should be reviewed, if there is a question of a substantial question of patentability, and then they have to just agree with themselves. And if they don't do any of that, they don't really have a job. I think that the built-in bias was just never a good thing. And I think that that's been drastically corrected with how these things are instituted, and I'm a huge fan.
So there'll be a lot of people on the petitioner side that disagree with just about everything you just said, Brad. But I do think it's pretty inarguable to say that back at the dawn of the PTAB in 2011, judges were hired to get rid of quote-unquote bad patents, whatever that might mean. And I've always said that when you're a hammer, the whole world looks like a nail. So I don't think it's shocking that those judges that came onto the PTAB at that point in time would have a higher than expected or predicted invalidity rate and a higher than expected institution rate. And I think that's exactly what we saw for about 14 years or so until this past year.
Yeah, you really do. It's natural human behavior. Like if you set up a witch hunt to say, go find witches, and you hire people to do that, they will find them. Like it's just human nature. You've seen that time and time again, and in every industry, in every government, that if there's a boogeyman out there that you're hired to go after, you do. And the irony that you and I have discussed is that the patents that go in front of the PTAB tend to be the highest quality patents out there, and yet they were still getting squashed at this like a crazy rate, 75, 80% at times. If you're thinking the checks that go into those patents to bring them to court, at least the ones that I work with, and to have them killed at such a outstanding rate was insanity, and I don't think it was what the whole system was built for.
This is going to be a great conversation because there's a lot of stuff there for us to chew on. And as I mentioned, I'm getting ready for this PTAB program, so I've been reflecting on the PTAB. And one thing that has become clear to me, and it's really been clear for 15 years, you can make PTAB statistics say whatever it is you want them to say. And I understand some people would take issue with you saying 80% of patents at the PTAB go down or 80% of claims go down. And if you factor in all those cases that settle, which is really just the patent owner capitulating, then it is less than 80%. But if you look at the cases where the patent owner did not capitulate, the patent owner continued to fight throughout, and there was a final written decision, it's clear that 80+% of the claims and 80+% of the patents do go down. And while I know some are going to dispute this, the reality is low-quality patents never find their way to the PTAB because the PTAB looks at valuable patents, or at least those patents that are valuable enough to fight over in what is not a cheap proceeding for either side.
Well, you have to look at the cost. Jim can phrase it better than I can, but just the cost of defending a single patent at the PTAB is about what, Jim?
Probably $400,000, something like that.
So that's one patent.
And that's just for one patent. If we're talking about patents in the pharmaceutical space, it's going to be way more expensive than that.
So if someone's suing you for a patent and it's frivolous and they're just looking for $20,000, $30,000, $50,000, they will not participate in the PTAB system, but nor will the person who's defending against this frivolous patent, because it also costs the petitioner a lot of money as well. So
actually more, probably.
Probably more. So the idea that you could just do away with the dog collar patents or the dog bone or whatever those ones were, the system wasn't built for that, and that's not what it does.
Okay, so let me ask this, because I know that the attorney's fees, as we just said, are high, but what is the cost to actually get one of these IPRs on file? Jim, do you know what the answer to that is?
Yeah, so I'm going to get it wrong. Brad and I were just talking about this, but the filing fee is within spitting range of $50,000 plus minus $10,000, I think. I'll have to correct us. And then if you don't get instituted, then you get a refund of part of that.
So, but if like a real patent troll, whatever that means, and we can come back to that in a minute, but if a real patent troll is trying to shake you down for 20 or 25 grand, that is half the filing fee.
Yeah, that's right. At that level, it certainly doesn't make any economic sense to petition for IPR. Occasionally you'll see frequent defendants, try to make a point of how tough they are so nobody even bothers them for the small amounts. So that could possibly be logical to overspend in that area.
Yeah, to have a deterrent effect, I suppose. But if you go all the way back to when the PTAB started, what we were told was we were trying to address the patent troll problem and the low-quality patent problem. And I've seen no evidence that that's actually what's happened. And the other thing that occurred to me today, well, let me take a step back first. My focus as a patent attorney has always been on software, and it has frustrated me to no end that we have a patent eligibility test that requires determination of what is an abstract idea, and the Federal Circuit and Supreme Court have simply refused to define what an abstract idea is. These terms matter and the definitions matter, and where that becomes relevant to the conversation we're having today, what really bugs me about this whole patent troll issue is we've never defined what it means to be a patent troll. What is a patent troll? I mean, I know we joke about it. A patent troll is simply whoever is suing me, but it really just can't mean that. It has to mean more. So how could we possibly set up a system to get rid of patent trolls without defining what it is that we're trying to get rid of? And I personally think that this is precisely what has led to where we're at right now, where you have a system that's supposed to do one thing, get rid of these extortion artists, get rid of people who are shaking down others. But we don't know who these people are, and we can't agree on a definition. This is front of mind for me right now because we constantly at IP Watchdog deal with copyright trolls who make patent trolls look like a bunch of Boy Scouts. So I am sympathetic to the patent troll narrative, but we have to define what these terms mean. I know we're not going to solve this today, so let me slightly pivot and bring us back to the conversation. Jim, before we started recording today, you told us something interesting about NPE institutions at the board. Can you share that with everyone?
Sure. Some statistics came out recently that showed that the percentage, the institution rate for NPEs has dropped quite a bit more than the institution rate for operating companies.
And we were wondering why that would be the case. And I think I steal a little bit of your thunder, Brad, when I say, well, that's not shocking, and it probably always should have been that way, because NPE-owned patents are much higher quality. And yes, I did actually just say that, and I realize some of you who are listening in your car are now just driving off the side of the road. But I think it is inarguable. You just can't argue NPE patents are better.
Well, if you look at sort of how the structure is built, say, pretend you're an operating company and you think that your competitor or whoever is infringing your patents. Who has the decision of going after a patent lawsuit and how do you fund that? So someone in the board or someone in the executive team might consult with their attorneys and say, let's go after it, and we'll just pay our attorneys hourly and move forward with the lawsuit. NPs tend to have a much different structure.
Now, isn't it also true, though, that some operating companies in that position will say, well, I don't want mutually assured destruction, so I'm going to sell my patents to an NPE because they should be enforced?
Well, that's a whole other avenue there.
Well, I've always been told, and I'm sure you guys have heard these rumors as well, that some of the largest patent-owning companies, some of the largest operating companies with patents, had historically sold portions of their portfolio to NPEs on purpose, based on the belief that they would go after the competition, and whatever was bad for the competition would be good for them.
A lot of companies do it for a lot of reasons. It isn't always just what's bad for my competitor. It's often just a recoup of investment. We put a lot of money into these patents. We need to see a return. And it's also expertise. You don't give yourself a haircut, right? So should you go off and manage your own patent litigation? So you often want to turn to people that do it for a living. That's just sort of how economics works. So a company like...
I cut my own hair, by the way, in case you were wondering.
I figured that one. So if a company wants to use a professional to enforce their patents and they come to us and do that, first thing is that the NPE will probably take a closer look at the patents. And to take a step back, remember that NPs aren't just creating their patents out of thin air. They're getting them from somewhere. They're getting them from operating companies, by and large, or research institutions. So they do come from the economy, right? And so if
it seems like the days of the Lemelsons are kind of over. People who are just trying to invent things on paper to shake down folks for money.
I think
seems like most of the asserted patents are originating with operating companies.
I think so, yes. From what I've seen.
And so they're real technology, real investments.
It's real investments, yes.
And when an NPE is going to buy patents, when they're looking for patents, they're looking for patents from operating companies, university-owned patents. These are good patents, well-written, well-prosecuted, reputable lawyers involved, all up and down the stream. And it happens that those patents are also valuable. Maybe some of the companies wanted to offshore the litigation to others and get a back end so they didn't have their fingerprints on it. But these are not bad patents. They're picking from the good pool to begin with.
You're picking from the good pool. You rely heavily on your counsel to help you pick. Now, it may be because that's part of your fee structure or for whatever reason, but NPEs listen to their counsel a lot more as far as picking the good patents. And then because of how a lot of NPEs structure their finances, there's often investors that they then need to get either their buy-in or their feedback or their comments on. And often then the investors, to make sure they're doing something right, hire their own independent counsel. So you can get like 5 layers of professionals looking at a patent before it gets filed along the NPE route.
And don't forget the law firms, like the position I'm in, we're usually faced with doing some contingency work. And I'm not going to go for that unless I think it's, everything is perfect about the case, because things are never perfect about the case. So I want to at least think that this is a really strong patent going in.
Yeah, and a lot of patent attorneys don't really understand that. When I started my career, I started doing general civil litigation, and a lot of the partners at the firm were doing contingency representation on various cases of different sorts. And the one thing I learned straight away was if you're going to offer contingency, you have to have 100% certainty the day you take the case that it's going to settle, because that case is never going to look as good as it does on day one. Once the depositions happen, once the other side starts investigating and submitting evidence, all the warts show up. So you have to be certain from the beginning.
I've heard you say that before, and it's absolutely true. And that's what we look for, is one that's really good on day one.
And Jim, if I can just ask you this follow-up, it's my understanding that funders, when they're looking at cases, really like it when the attorneys involved, the law firms involved, actually have a stake in the game when they are taking it on contingency. Is that correct?
Yeah, they do. That's right.
And if I can just close the loop on full circle back to operating companies, is NPs are filing because it's a business consideration. It's a monetary consideration. Operating companies may have other things in their minds than just pure economics. So there's a whole slew of business considerations of why you might file a patent suit as an operating company. So that's just one more reason why it may not just be the same quality as an NP.
And one thing that has irritated me in this whole conversation is when people talk about funders funding bad cases, low quality cases, because that's just not the way it goes. These funders are investing millions of dollars, many millions of dollars, several $million up front, maybe $10 to $20 million or more over the length of these cases. So it's not my experience to see that these funders are funding cases that are just bad. They're not into throwing money away.
No, they didn't get their money by being stupid.
Exactly. Unless you inherited your money from family, you do not make money being stupid and reckless. That's just not how it's done.
That's right. So if we can talk a little holistically then about the changes, as I said, I'm thrilled. I think that the patents are perhaps getting the scrutiny that they deserve now, rather than just the kill squad. But holistically, even though I'm thrilled with the changes, economically, it's not a good alternative to litigation, because what we're seeing happen now is that people will still file at the PTAB. If they get discretionarily denied, then they will file in the reexam. And now we've seen this huge spike in reexams, and reexams get instituted pretty easily. So between, like ridiculously easy. So if you're looking at it as an alternative, you're still spending, we figure, 40% of your money for discretionary denials. You still have to fight that. So that still costs. And then once you're instituted, then you still have to then go through the whole reexam process. So overall, it's still costing the patent holder about the same. But the benefit is that now you're in a reexam, which is you arguing with the patent office about the claim. So I'm thrilled about the outcome. I'm thrilled about what's happened at the PTAB because you have a better chance of preserving your patents and preserving your property rights. Overall, though, the price hasn't changed at all.
I'm thrilled enough about the change in prospects for inventors and patent owners that I've decided to expand our litigation. So we're doubling in size now in our firm to account for that, and doing contingency litigation for patent owners, which I don't think I would have done before this year and the changes of the PTAB.
So let me ask you guys this. Do you think this is a long-term change, or is this going to be just a short-term change? And the reason I ask that is because it's hard not to notice the whiplash that's going on in PTAB policy. We started with David Kapos, who set up the PTAB, and he was there for maybe about a year into the PTAB. And then we've had a string of folks in that seat as director or acting director or commissioners who have been elevated to assume the powers and duties of the director. And we've gone through a lot of change, from Michelle Lee to Andre Yanko to Kathy Vidal, now to John Squires. And I just wonder whether we're ever going to have any settling down of what's going on. So do you think what's going on now is long-term, or are you thinking maybe just over a span of a couple years until whoever's next gets in there?
Yeah, we don't know what's going to happen in 3 to 4 years, but I'm happy with what's happening now, and some of the changes are going to be harder to undo than others, but it's all possible that all these get undone. Yes,
it seems that Squires has learned the lessons that you've just laid out, Gene. That it's like a pendulum back and forth. It depends on the whims of the the next administration or the next director. I say that he's learned some of those lessons because he has already proposed a rule package in his first however many months he's been on the job. And that's what you have to do to make permanent change. So I'm glad to see that finally somebody figured that out.
And that's why you need to come in as director with things you want to accomplish on day one. You know what they are, and you're ready to do them, and you launch, because it can take every minute of 2 years to get some rules through. And that's not even if they're going to wind up being challenged. So I also think it was very critically important at the beginning of the Trump administration that they hired Coke Stewart to be deputy director, and then that allowed her to become acting director. And because of Secretary of Commerce's Howard Lutnick's involvement in the patent area, he's a prolific inventor. He knows the space. He had ideas of what he wanted to accomplish, and then he gave marching orders. And Coke Stewart, while she was acting, did go and do a lot of things that you wouldn't maybe normally expect to see from somebody who's in an acting capacity. And then once Squires became director in September, he really kind of put his foot on the floor, pedal to the metal, if you will, and things are getting done. And while I'm happy, and I know many others are happy as well about what's going on, I have to wonder whether or not things are going to snap back at some point in time.
Yeah, I think it'll take a long time. With the rules package, it's harder to undo, right? If the next administration wants to continue to beat down on patents, they can try. But I think what's happening now is it's establishing a good roadwork. It's going to be harder to undo. But to what I said earlier, it's possible. It's possible that whoever the next commissioner is can undo quite a bit.
It would take a while to staff up again to handle as many IPRs as they have been. They've already gotten rid of PJs. And I have it on good authority that recently some of the APJs asked, well, we're running out of work because of the non-institutions, and we've been put half of our time or a portion of our time, all of us, on ex parte appeals, which the backlog is now down to essentially zero. And so what is there for us to do? And they've been told, well, there's plenty to do at the office, like Office of Enrollment and Discipline, or some other suggestions that people aren't going to be real happy about.
And one of those suggestions is rumored to be moving some of the PTAB judges into the CRU, the Central Reexamination Unit.
That's logical. CRU needs help, not only because of the huge recent spike in workload, but because they had lost so many people as well.
So let me ask you guys to look into your crystal ball for a moment, if you will. What are you looking at happening in the future? What do you expect to see moving forward?
I think you're going to see less people filing at the PTAB. I think there's sort of the institutional groupthink is that because we've been filing at the PTAB, that's what we are going to continue to do. If I was fighting a patent, I don't think I would be doing it. I think it reveals a little bit too much of your 102, 103 hand. And then to think that, well, if the PTAB doesn't work out, we're just going to go to a re-exam. The re-exams have always been around, and people didn't really file in them before, and it doesn't really make a lot of sense that, oh, well, now that the PTAB's not good, we're going to file re-exams. They're suddenly better than they were for the past 25 years. I'm thinking that eventually that will sink in, and you'll probably see less filings, but it'll take a while before that sort of groupthink mentality works its way through, is my prediction.
I'm curious if the excess APJs do get put over at the CRU, whether they're going to bring with them their kill rate. I hope not, but.
Well, the CRU kill rate is pretty high.
So the statistics I see say that in 10% of patents, all claims are confirmed. In 10% of patents, all claims are canceled. And in other 80%, there's amendments. And now people take that and say, they had to narrow their claims to avoid the prior art, and there's intervening rights, so it pretty much killed the patent. I don't think that's true, because many of those in that 80% center are just adding new claims in addition to getting the old ones confirmed. And the PTO doesn't break that out separately, but I know experientially that that's what we do sometimes.
Yeah, and it's kind of careful what you wish for if you're filing the ex parte re-exam, because the patent holder can end up with better claims, more targeted claims.
I get that, but that 1080 in the middle isn't the historical numbers for the CRU, is it? I mean, the last time I looked at this, I was of the belief, or my recollection is at least, that it was much closer to what the PTAB numbers are, where you have about 70% of the time all claims are lost, up to 85% of the time at least one claim or some claims are amended. And is that not the case, or is it just that it has become 10-10-80 given the lower number of cases at the CRU over the last several years?
I think you're reading people that make the mistake of saying that big piece in the center where there's an amendment, that counts as a loss for the patent owner, when it really doesn't.
So I'm going to have to go back and take a look at those statistics and see if I missed something there. So thanks for flagging that for me. But this would be good for patent owners if the central reexamination unit is not as bad as the PTAB, I suppose. I mean, there's a lot that goes into it, I know. But let me ask you this, Jim. If in re-exam the patent owner does get a lot of additional claims, and I know that for many that has been a strategy, sort of like a deterrent, where if you're going to take me into re-examination, I'm going to come out with a stronger patent and we're going to have a lot more claims, because at that point, the excess claim fees just don't matter. So with those extra claims that get added, are there any intervening rights? What's the situation there?
Yeah. So if you can only enforce the new claims, then the damages are only going forward.
But that would be better than intervening rights, because with intervening rights, all you can get is nominal damages, and that's just going to wind up being $1 perhaps, right?
That's right.
So I suppose the big question that remains that we haven't really touched on yet, at least, is what effect does this have for litigation? And then maybe the secondary consideration or question is, what is this doing for patent valuation? Has it changed what's going on in litigation yet? Has it changed patent valuation yet? Because what I've heard, at least anecdotally, with respect to patent valuation is that nothing has really changed as of yet. What are you guys hearing?
I'm not seeing a big change on sort of the secondary market, but it's a very opaque market. Most transactions nobody knows about. So I think it's a wait and see kind of thing. So.
Yeah, I've heard funders say it doesn't move the needle that much, but I'm putting my money where my mouth is and saying it does, because we're taking on contingency fee cases now.
I just don't see how this couldn't matter and how it wouldn't change things, because the PTAB has been like a wet blanket on the industry for so long. So if there's less of a PTAB risk, it would seem to me to just be better.
It should, but as I said earlier, the alternative that you're going to the PTAB and then the re-exams, that cost is still there, and it's basically still the same. You do still have to deal with re-exams. You don't know how the district court is going to react to wanting to do stays to re-exams. I think that's a big unknown. And quite frankly, the district court hasn't changed, venue hasn't changed, and the federal circuit hasn't changed. So there's a lot that we've gotten rid of, like a really big thorn that was killing patents that were very valid and shouldn't have been killed. But it's one part. So that's why I think maybe you're seeing a very slow change in overall value.
Well, it is certainly true that the federal circuit hasn't changed, and I'm sure they don't like it when I say it, but this federal circuit is just not pro-patent. They're not in favor of patent owners. They don't rule that way. And the only time they seem to overturn the PTAB is when the PTAB has ruled in favor of the patent owner, in those few cases that has actually happened.
It's not good. They don't like patents. They have this sort of secret damages number that they get mad that they say they don't have. But
well, they can say that there is no absolute cap on the number of damages or the amount of damages that they would be willing to affirm. But we all know that's not the case. They do have a cap. And a lot of people talk about it being $1 billion. I don't think it's anywhere near $1 billion. I think this federal circuit, the cap is probably a lot closer to $100 million that they'd be willing to affirm than it is to $1 billion. And at some point, it's just frustrating, because when you operate in a space, as we do in so many aspects of the industry, where there's several dominant players, then you're going to have 80, 90% of the industry in those hands, and then only a bunch of small players, very small players at the fringes. And when you have infringement, the math is the math. The numbers are what the numbers are going to be, and the damages can get seemingly silly, not because they're not warranted, but because there really is that amount of harm. So I just say, and I know I just said it, but the math is the math. And at some point in time, it seems like the Federal Circuit has to come to grips with that.
Yeah, the math is the math. In my hometown, there was a police officer who claimed that he'd pull you over for any speeding. And everybody knew that if it was 15 over the limit, that's where you got hit. And he claimed that wasn't true, but that's what happened. You go 15 over the limit, you get pulled over. You go 12 over, you go 10, you don't. So if the math is there and the numbers are there, they can claim all they want, but we know that the scrutiny that higher damages get is enormous.
And something has changed, because I was reviewing a case the other day from like the second year that the Federal Circuit existed, and it was affirming an award of $3.77 billion against the federal government. It's like, I can't imagine that happening today.
No, that would never happen today. I think we all can agree on that. Let me pivot, though, if we can, because there's one thing I want to raise that, and I want to be careful how I say this, because I really do like so much of what's going on at the Patent Office right now, and how could I not like it? A lot of what the Patent Office is doing are the types of things that I've written for much of the last decade, at least, if not more, need to be done. For example, I have been writing about quiet title over and over and over again. A lot of people thought I was crazy, thought it was never going to happen. And here we have essentially the Patent Office focusing on quiet title. They're calling it settled expectations, but that's really what it is. But the issue I have with settled expectations is the arbitrariness. And I know where the 6-year presumption comes from. It has to be tied to the fact that the statute of limitations in a patent infringement proceeding is 6 years. But it just feels to me like that came up out of nowhere, really. And I think I would have preferred to have said at least some factors. And Brad, as you know, we had a professor at Franklin Pierce, his name was Hugh Gibbons, and he always only half-jokingly told us when we were in law school that if there's ever a test that has more than 3 factors, it's because the decision maker wanted to be able to do whatever they wanted to do whenever they wanted to do it. So I think I would have come up with a 4-factor or more test, maybe sliding scales or something, to determine when is there settled expectations. Because I do hear the other side saying that, well, how would we have known that that patent would be used in that way against us? And I think that maybe is a valid concern. I don't know that it's a factually valid concern, but I think that type of argument resonates. And I think it's the resonating of the argument that I am having the issues with, not because these are real necessarily, but I would just prefer to do things in a way that the other side, who has taken advantage of the system for so long, I mean, let's just face it, petitioners have had a one-way street to kill patents at the PTAB. So it's a little hard to be too sympathetic to what they're saying now, and they're claiming arbitrariness. But by the same token, this has happened very fast. It snapped back just since the beginning of the Trump administration, and things are changed. And I think if they go and they say, look, to members of Congress who maybe are on the Agriculture Committee, maybe they're doing Native American affairs, but they're certainly not focused on IP, then they go to these people and they'll say, well, this is what happened up to 2024 and through 2024, and here's what's happened starting in 2025. It's a totally different universe. And I think that doing it maybe a little bit more gradually, or maybe with more rules or factors in place, would have been better, because I just think that when the snapback happens like this and it feels arbitrary, that is not necessarily going to be in the best interest of patent owners long term. Because I do want to see systemic change that lasts. And I guess that's really just where I'm at. What do you think?
I think I disagree with you on that, because I like the bright line rule. A lot of people in law like the bright line rule. And sometimes it's like, even if this is going against me, at least I know where the line is and I can work with it. Whereas if it's really fuzzy, you'll spend a lot of time arguing in that fuzzy zone, maybe to no effect.
I disagree with both of you, because I don't think there is a bright line test. I know they say 6 years, but I think it's more of a presumption.
I think it is becoming a presumption. But I guess what I'm saying is when the change was made at the very beginning, I personally would have been a little bit more comfortable, a little bit more secure, I think, feeling secure at least, if they had come up with some guidance and let people know where these were going. And I get that you want to see the cases, and the whole point of the common law developing is to see where people are arguing, see what things are happening, and then kind of build step by step, brick by brick, and come up with these tests in that way. And I don't want it to sound like I don't think it's a good idea. I think it's a great idea. I think settled expectations should be a consideration, should always have been a consideration. Patents should have quiet title. I guess what I'm just worrying about is that when things change so drastically, and you see this in a whole bunch of areas right now, people don't like change, and then it becomes the problem is the change, and the focus is not on the substance. And maybe I'm just overly worrying, because I do like the direction it's going, and I hope it continues to go in this direction. At the same point in time, I really do hope we come up with a solution for those folks in the industry, those real trolls, the patent trolls, who are really abusive and really are taking advantage. And I don't know what the solution there is, but I do think that this whole path was started to address that problem. And ironically, that's the one problem that hasn't been addressed. And so I think we all need to get a lot of people in the room to try and think about what can be done on that front. Now, before we get too far away from it, I want to go back a little bit and talk about the Federal Circuit and the damages. And I think one of the other problems that the Federal Circuit has is that they're just living in a different world, in a different time. The judges are a bit older. I think it may be the oldest court in the federal judiciary. And it seems like they are just not comfortable with really large damage numbers, or even modestly large. I mean, or sometimes not even large at all. I was shocked when they had rehearing in Google versus Echofactor, because Google lost $20 million. And when that happened, I was like, what are we doing here? If I was on the Federal Circuit, which we all realize is never going to happen for a whole variety of different reasons, but if I was on the Federal Circuit and they came to me and they said, should we hear that case en banc? The answer would be an emphatic no. I don't care whether I disagree with the ruling. I don't care whether I think it's the wrong ruling, but only $20 million is at stake, and Google's involved. I mean, Google's worth trillions of dollars, right? I mean, this economy is gigantic. Is that really the right vehicle to say anything en banc as the entire court that is supposed to move forward and is going to give guidance to every case that follows? I just don't think there's enough at stake. I think if you're going to do en banc, and there's plenty of reasons to do en banc, and the Federal Circuit, I think, has been remiss by not going en banc enough. But are you really going to take a case where there was only $20 million involved with one of the most wealthy, lucrative corporations in the world? It just doesn't make sense. There's this disconnect. We're missing, it's like ships passing in the night. We're missing something here.
Yeah.
I feel like the system has lost sight of the wisdom of the Constitution framers, Article 1, Section 8, to promote the progress of the useful arts. That's why we have patents, and that's what patents do. And somehow we've lost sight of that and allowed inventors to be demonized.
Yeah, and then we've also lost sight of triple damages.
Absolutely.
Up to triple damages. Like, it goes to your point, if I can make 50 billion and maybe 10 years down the road pay 400 million, like, unless there's a multiple on damages, the incentive to infringe is just, it's always there. The worst case scenario is I pay for a license that I could have paid for 10 years ago.
Yeah, and in the worst case where they do find willfulness once every great while, they never go 3x, right? They go 1.25x or something like that.
Something mild.
But even if they do 3x, and we're talking about a case where there's $400 million in damages, like maybe think about Apple versus Samsung, that only gets you to $1.2 billion. And that, for those companies, is not a lot of money. And I don't mean to nitpick at anything that you've said, but the truth is 3x is simply not a deterrent for most of the big companies that are operating in this space and that are alleged to be infringers over and over again. I think we need to get more serious about attorney's fees as well. And, just thinking about it, what we're really talking about here is what we're pining for is the Federal Circuit that we had for about 10 years, maybe 15 years, right after it was created. the golden era. And that's just not the Federal Circuit that we have anymore. It's just not.
And it was created with a purpose. And the purpose was to foster innovation and pull us out of the what they call it, the great malaise.
But let's not forget, the Federal Circuit was started as a patent court. That was the whole purpose. I realize they have a whole lot of other areas of jurisdiction, but the reason that they have those areas of jurisdiction is because we didn't at the time, and maybe we still don't, want to acknowledge that a specialized court is appropriate. So we had this aversion to specialized courts, so the Federal Circuit winds up getting these 30-odd areas of jurisdiction, created to be a patent court, but they handle Indian cases, they handle veterans cases, they handle merit pay system cases. And it just strikes me that this aversion to into a subject matter area specific court, into a specific court with a specific jurisdiction, just doesn't make any sense in the world we live in today. Because if we were talking about practicing law, I just don't think you can hang a shingle anymore and do all kinds of areas of law. If you did that, whether it was wills, DWI, contracts, leases, patents, whatever, it would be malpractice today.
I also think that some judges who are good at handling patent cases, their outcomes aren't biased one way or the other, but they're efficient. Patent cases are, some people say, 3 times more complicated than an average case. And so having a judge that's good at doing that gets demonized for handling a lot of patent cases. It makes no sense to me.
Good at simplifying things.
Oh, good at simplifying things, but also just managing. Like a markman doesn't exist in any other court. Like you need to know what you're doing.
And maybe they've actually been a part of a markman case. Maybe they've been a lawyer on patent litigations that have had to deal with all of these issues. And there are at least several district court judges who were patent litigators before they took the court. And maybe most notably is Judge Albright in Western Texas, but they took away his cases. Through rules, they became uncomfortable, at least the Western District did, with him having so many cases. And this became an issue in Congress, and Senator Tillis raised it and wanted to inquire about why it is that one district court judge has so many cases. But you look at what's going on in the other side of the same state. And now with Judge Albright having not nearly the number of patent cases as he once did, you have Judge Gilstrap back to having a ton of patent cases. He's always had a lot of patent cases, even when Judge Albright was having a lot of his cases. But Judge Gilstrap has maybe 25% of all patent cases.
But if you've ever seen how he manages it, it's a tight ship, and he knows what he's doing.
I get that. And I'm not trying to say anything bad about Judge Gilstrap. I like Judge Gilstrap. I think he does a good job. He does both sides justice. His numbers are about 50-50 for patent owner versus defendant. So I think he's doing a good job. I guess what I'm just saying is how can you say that it was wrong when Judge Albright had a lot of cases and it's not wrong when Judge Gilstrap has a lot of cases? And for the record, I don't think it's wrong when either of them have a lot of cases. I don't see the problem in giving these cases to people with experience and who actually want to handle them.
And Judge Albright, like Judge Gilstrap, is not biased either. He's just runs a tight ship, like you said. Mm-hmm. And I like him because he granted us a preliminary injunction against patent infringement. But to show that he's not biased, I will tell you, it's the only one that has ever been granted by him or anyone else in the Western District. So that was a one-off.
So let me tell you, if somebody were ever to come to me and say, what would you do, Gene, in order to kind of streamline this whole system and make it better? One of the things I would start with, I think, is looking at a patent court. I know we tried that once upon a time. It didn't really go anywhere. It was a pilot program. It wasn't funded at all. There was no benefit to being a part of it. But even then, you still had all these people say, oh, we can't have a patent court because you need to have a jury of your peers in a location where there's venue and all that sort of thing. I get that. What I would do is I would create a patent court that is modeled after the Court of Federal Claims, because I know the judges on the Court of Federal Claims do ride circuit, so to speak. They'll go out and they'll have hearings and trials in courthouses all around the country, wherever it is convenient for the parties. And then that takes into account the issue of having a local jury, which we seem to want to be very protective of. And I get it. I understand that. But I think why not have these judges that want to hear patent cases actually hear them all over the country in local courthouses where the disputes are ongoing, and they understand patents. They are not afraid of the cases. Some of them actually like patent cases. As we mentioned, some of them were involved in patent cases when they were in private practice. So I would do that, move them around the country, and I think we get a much higher level of decision, and we get a much smoother system, and it would certainly take away from those judges who don't really want to have patent cases. I think that is got to be a part of the solution, or at least a consideration moving forward.
So I like that idea. I think you can achieve most of that in a easier way, which I know some courts have done. I know the Central District of California did it. They let people sign up, let judges sign up to say, I want to be on the patent list. And the other judges that haven't signed up, they can, if they want to, get rid of their patent cases to those that have signed up on the list. I feel like that could achieve much easier, much of what you...
Well, I like that idea. I don't think it accomplishes everything I was hoping to accomplish, but it would have the benefit of being something that could be done across the courts all at once without any hesitation. It could be done tomorrow if the chief judges in these various courts wanted to do it. But the one thing it doesn't achieve is, if you look at what happens with venue has become very restrictive over the last, decade or so. And it doesn't address the situation where you may need to be filing a patent litigation case in a jurisdiction where there are really no judges that are that familiar with the area, and maybe even no judges that really want to hear a patent case. So that isn't the end-all be-all solution. It's one that we can implement immediately, though, Jim, I think. But the one thing is there are solutions, and I think we just need to be talking about these solutions so we can get to a better vision for the future.
There are, and I think time is important for two reasons. For the public, it's important that a patent case not take up a lot of resources that can go to 3 different matters if it's not being handled efficiently. So it makes sense to put the people who are efficient at running a patent case in charge of those patent cases, so that the rest of the judiciary can take on 3 more cases. Also, from my own maybe more biased point of view, is one thing that benefits infringers is time. And if they can delay things, they do. And an infringer will just try to get away with that. So I think that that shouldn't be allowed.
Well, from your lips to God's ears, and hopefully we'll have some resolution for that while we still are in practice. I mean, sooner rather than later. I think the real problem that has happened in the patent system, particularly in the patent dispute area, in the enforcement area, is the law has grown up over the last 10 to 15 years, maybe even longer, to force people into the courtroom and out of the boardroom. Nobody wants to settle because the law is in their favor. And I say nobody. It's the patent owners would love to settle an amicable way, I think. But the accused infringers, the defendants, really have no incentive. The deck is stacked against the patent owner. The law is in favor of the accused infringer, and there's just no reason for them to want to settle. It may even be malpractice for attorneys, whether they be in-house or private sector attorneys, to be advising these companies to take licenses when they can string these cases out for 10 or 15 years or longer. And if they do wind up paying, they're going to pay in money today based on damages that were 10 or 15 years ago, without any attorney's fees and without any trebling, as we've already gone through. And I think that that's just not a great universe. There has to be a way to drive people to settle these cases.
It's very true. I've had the other side say to me, like, we'll keep this in court, we'll keep this in appeals, and we have nothing to lose by doing it.
All right, guys. Well, thank you very much. I really appreciate you being here. This has been a great conversation. Thanks for coming.
Thank you, Gene.
Thank you, Gene. And Gene, thanks for everything you do for the patent community and the country. You're a great American, a great person.
Thank you for listening to IP Watchdog Unleashed. We will be back next week, and we hope you will join us again. In the meantime, please be sure to visit IPWatchdog.com to read all the latest news and information about what is happening in the intellectual property world. And also be sure to subscribe to our free daily email newsletter.